Greetings, Mr. Briggs, Batcher, Cotney, Green, Mikovic, and Miss Nelson, along with other counsel and former attorneys with Adams and Reese, receiving this conferral record. I've represented myself in court before and had conferral with opposing counsel on the discovery process cordial, direct, documented, and professional. There is a unique process in the court's processes to minimize the exposure of what a party and counsel would hope to keep private. As the case progresses, it becomes more public and transparent, as intended by the court's processes. This video is intended to preserve and explain the conflict of interest concerns I raised in conferral while not giving away much of my impeachment evidence. My concern that the record contains discovery, deposition testimony, prior litigation materials, and payroll evidence that appear to contradict positions being advanced relevant to this case, because those issues affect proper parties, discovery, credibility, and conflicts. The gamesmanship by Mr. Briggs is concerning. In my honest opinion, Mr. Briggs deliberately engages in actions to prevent the disclosure of relevant and admissible evidence. I have conducted depositions before and never had an attorney interrupt a question to interject something which altered direct answers in the testimony and directly interferes with the truth-finding function of a discovery deposition, and was coaching of the client until Mr. Briggs did so in this case. Please consider this a final conferral record regarding conflicts of interest and direct adversity among represented parties. Based on the discovery to date, the evidence shows conflicts that go beyond ordinary litigation disagreement. When I went to update my witness list to include Mr. Batcher and Mr. Cotney, because prior litigation records and testimony may bear on the credibility issues raised by Billy Tolson's deposition and directly contradict the answers and affirmative defenses, I went to the Florida bar to locate contact information for potential attorney witnesses and learned that Mr. Cotney and Mr. Batcher are now with Adams and Reese, along with Mr. Roscoe Green, who may also have relevant knowledge. I believe Mr. Briggs' description of Cotney Construction Law as a former firm was materially incomplete and misleading, because public information indicates that Cotney Construction Law and Adams and Reese were connected through a 2022 merger. That matters because records from the prior litigation may now be within the custody, control, or institutional knowledge of Adams and Reese. In my view, Billy Tolson's deposition testimony and the prior litigation's records made the additional subpoena and request for records highly relevant, especially where Adams and Reese did not meaningfully communicate about the subpoena. During the first weeks after Adams and Reese appeared as counsel, my conversation with Mr. Briggs focused heavily on proper parties to the litigation. I directly told Mr. Briggs that Alan Cooper deliberately lied to Trent Cotney. Mr. Briggs did not want to discuss that issue during the conference of the parties, which he deferred until discovery began, and he then used the issue to resist discovery. The subpoena ducasticus for deposition issue involving Billy Tolson is a prime example, because he was not initially sued in his personal capacity. Counsel objected to and resisted the production of records that were relevant and advised as an advocate of Billy Tolson in his personal capacity to not bring the records of the subpoena. I imagine the same direction was given to Mr. Mikovic. Based on the deposition testimony, I believe counsel's sleight of hand advice affected both Acker Construction and Mr. Tolson personally, which is part of why I view the issue as a conflict and discovery obstruction concern. In short, Adams and Reese continued representation raises a serious conflict issue because counsel appears to be advancing or relying on the knowingly perjured testimony of Billy Tolson that is directly contradicted by defense's own discovery, payroll records, and the company's own documents. Not to mention the knowledge Trey, Roscoe, and Trent are personally aware of and Mr. Briggs is directly aware of. Mr. Billy Tolson's deposition, I understand that Tamara Lamb and Alan Cooper were involved in preparing the answers and affirmative defenses that denied the truth that I normally worked more than 40 hours weekly. I provided evidence showing required minimum 40-hour weeks, later becoming minimum 50-hour weeks, and carrying over hours from one pay period to another. I believe these facts are directly relevant to this Fair Labor Standards Act's claims and to whether the pleadings should be corrected, discovery reopened, or conflicts addressed. I also know the employer's own discovery shows I average more than 60 hours per week, which makes the continued denial of those facts a central record issue. I do not assume that Mr. Briggs' conduct represents every attorney at Adams and Reese. My concern is additionally that the current record may require attorneys within the Adams and Reese firm or attorneys connected to the prior litigation to become witnesses on issues involving records, including newly discovered and recovered evidence and records of Fair Standard Labor Act violations, prior statements, custody of documents, and the credibility of client testimony. I have more than 20 examples from the prior litigation and have recovered recorded phone calls, the recording of which was directed by Acro Construction Management from 2017 to 2019, that may bear on the issues. I would prefer meaningful dialogue and correction of the record, the answers and affirmative defenses corrected, and the proper chain of custody of defense discovery reviewed, and my own discovery, which places things into proper perspective, part of the court record. But when counsel does not address the substance of these issues, the court may be left with incomplete or misleading advocacy rather than a fully developed record. Today, I am focusing on one document from the prior litigation, only 15 pages of about 5,000 pages of emails. Though counsel, Acro, Allen, and Billy know additional evidence exists. This document alone will hopefully refresh the recollection of counsel with Adams and Reese in the former litigation, which directly shows why the conflict issue must be addressed. In my view, the document relates to federal contracting representations, labor issues, and credibility questions that overlap with the facts and circumstances of the current litigation. I am not asking viewers to assume fraud or misconduct by counsel merely because I say so. I am showing the document, explaining it to refresh the recollection of witnesses, and preserving why I believe counsel should address the conflict, confer, and correct the record. It is also to show the essence of the labor kickback scheme to defraud the federal government by Acro Construction, Billy Tolson, and Alan Cooper. This is my timesheets, mileage, and expense reports from 2016 when I went from hourly to salary. These records seem to be mostly accurate. They represent the pay stubs that I have that coordinate with them, except for the 1 week of the pay stubs that are missing. This is going into an explanation of stuff that was conferred with counsel back in that litigation that involved hourly and salary differences, and directly goes to how Acro Construction uses their labor kickback scheme to defraud the federal government. I will get into that more in detail later, as the recollection of the witnessing of those actions by Mr. Batcher, Cotney, and Green have more relevance after showing that I actually have these records. They're accurate and are representative of actual costs, unlike when Acro Construction, as disclosed in defense discovery in the current litigation, shows that there were weeks where money was stolen from what I was promised. And I recently confirmed that the actual money was missing when I went and got my bank records from January 2026. This was record, after the agreement was made, this was actually money stolen off the paychecks, which happens on a regular and reoccurring basis with Acro Construction that I've been able to determine from numerous other victims of the wage theft. All right, here I have my pay stubs, except for the 1 week that I mentioned in the last clip. This is for the relevant time period that I will review and get into more detail when it comes to the involvement of counsel with Adams and Reese's witnesses. Greetings, attorneys with Adams and Reese. So I showed you that the timesheets, mileage, expense reports. Now here I go into where it is directly relevant, where Billy Tolson testified in deposition that he's never seen a timesheet where I've worked over 40 hours a week. Obviously, that's patently false from the defense discovery, but this goes to the matter that the attorneys with Adams and Reese are also witnesses to this perjury under oath. And knowing that the answers in affirmative defenses likewise denied that I regularly worked over 40 hours a week, which was prepared by Tamara Lamb and Alan Cooper, it shows that I may need to rely on the witness testimony of Roscoe Green, Trent Cotney, and Trey Batcher. Now, Trey Batcher wasn't included in this email, but I have reference to him later on in this dissertation. So, as you can see, this email was sent on January 12th of 2018, and the contracting officer, the on-site engineer, Billy Allen, from Acro Construction, and Liz were copied. And after I sent in this RFP 21, which later became a request for equitable adjustment, it was forwarded to counsel Roscoe Green and Trent Cotney. So, as you can see, I sent this a bunch of emails regarding requests for equitable adjustment. I'll show you the relation to that beyond it being an RFP. At 6:19 on January 12th, 2018, I sent a whole bunch of them at once, and then I forwarded a whole bunch of them at once at 6:24, just 5 minutes later, to counsel, since counsel had been retained in the case by Acro Construction. So the relevance to this is also directly related to the current litigation because it shows the labor schemes and goes from there. I remember that we were in a conference call regarding the litigation. I believe it was Trent Cotney and Trey Batcher that was a part of that conference call that I'm referencing right now, where I came up with the question, hey, this is an RFP now, and since we weren't paid for the work we did and we're claiming this money after the fact, isn't this an actual REA where we actually have to show the numbers? Because it was over, the RFP was no longer an estimate of what it would cost to do the work. It was a known fact of how much that work would cost. And the timesheets, mileage, and expense reports with the pay stubs covered every penny that was spent in regard to that REA. And also the documentation attached to this RFP, which is actually a request for equitable adjustment. So going into this, to refresh your recollection, the conference call was ended with the question remaining of how do we put this in the government? Do I need to change my numbers because this is more than what we actually paid for this that we're now charging the government afterwards? So the numbers breakdown I'll get into more detail, The conference call was ended. I received a phone call, I believe, from Alan Cooper, definitely reiterated this, was that he got a call from either Trey Batcher or uh, Trent Cotney and said that I should just put down the numbers that is given to me by the office to charge, even though everybody knew that it was over and above what should have been charged. So, as you can see, this is obviously addressed to the contracting officer and the relevant parties with the VA at that time. So, this isn't just an RFP, it actually is titled a request for equitable adjustment on the project, and it is dated accordingly. Just so everybody sees, Brian Garvin and Stephen Claybough are copied in it. And at the bottom, Alan Cooper, Liz Chastain, and Billy Tolson are copied from Acro Construction. So the gist of this RFP that became an REA was that we had a delay in mobilizing the job site. That delay was also during a time we were discovering numerous errors with the engineering on the project. And there were certain aspects of this that required somebody from Acro Construction, who happened to be me, go to the worksite location and investigate these errors to do our due diligence. The delay in the notice to proceed was part due to the government not really being prepared for us to be on site and working, even though we were told that would be the day that we were given the notice to proceed. I headed up to Nashville with a truck full of equipment and office supplies to begin the project and get up there, and the notice to proceed did not follow the pre-construction conference as we were told it would be. So during this delay, it specifically mentions me as a supervisor, was stationed at a hotel in Nashville and submitted the bulk of 35 RFIs. I'll go into the actual number of days I spent in hotels later because, of course, I document everything. And then I will go into how Acro Construction, using Trent Cotney, which is now Adams and Reese, as a veil, defrauded the federal government by requesting more than $24,000 for something Acro could legally only bill for less than $7,000. And this was done at the direct direction of the attorneys with Adams and Reese, according to Alan Cooper, where Alan Cooper evidently had conversations outside, and the records that reflect these frauds against the federal government are exclusively within the knowledge of Adams and Reese and counsel. So here it explains that we staged tools and equipment in the project laydown area, and due to the delay, we couldn't just simply move the materials from the laydown area. I went through and I specifically noted, and this is directly relevant to the deposition of Billy Tolson, that they refused to issue the notice to proceed, and it had to do with, and the main reason given was that we needed to provide a schedule. So we actually noted the average number of hours I worked during this eight-week period, and that the work specifically for Nashville included 12 additional hours per week. So what is significant also to mention, directly placed in this RFP, REA, is we even cited that that we normally have lower costs because I would get an apartment. However, hotel are included because of how it was in this issue. This is part of the discussions we had with counsel, and that it wasn't feasible to get a lease prior to the notice to proceed. So we essentially start out the project in hotels, and we'll go to lower cost living arrangement. And Acro, that is one thing is that they've that I can't complain about is that they, when it comes to the lodging part of stuff, there's times where they refuse to pay for hotels if I was in the middle of travel, where they thought I should have driven an extra 7 hours after I'd worked a long day instead of getting a hotel, where they refuse to fund it. But for the most part, the hotels are not subject because I was always paid back at a direct cost. Not necessarily all the costs related to staying at a hotel, but the lodging part was usually separate. And these were during the contract performance period. So the home office overhead was in addition to that. And it also notes that my additional supervision time and expenses are not included in home office overhead. And it should be noted, Chris Sweeney does not calculate his travel time in his timesheets. And I specifically attached all those timesheets. So the travel time, later on, you'll see that there was 6 trips from Florida to Nashville. And this kind of extrapolates the entire process of Acro Construction kind of having the employees take the burden. So I also make sure that show you that hotel and meal per diem is definitely unique and different. So on this project in the Nashville area, the meals and incidentals per diem is $59 a day. If you go back to the cost data sheets, the time sheets and stuff, they changed the standard during this, but the standard was $20 a day for up to 5 days a week, even though in many occasions I would work 6 or 7 days a week. So I was only able to charge up to $100 a week, and that changed from $20 a day just to a flat $100 a week during this time period. Also, my pay rate being hourly to salary was changed as well. So there was no hourly charge to the government for overtime work for the last 6 weeks. However, they still had me place that in there because that's how they scam the government out of money. So, a significant note in this also is that the home office overhead proportion was calculated separately by the home office itself. That I believe there was over $300,000 in annual billing that they claimed was attributable to home office overhead. However, there was only one person that worked over at the office, and I'm more than certain, because of all the burdens placed, that was numbers that were fabricated by Billy Tolson himself. So this kind of gets into the fact that it is an REA. It's not just an RFP. It covers work that occurred in 2016 when at the time I was switched from hourly to salary. And because I still have all the records except for the 1 week of pay stubs, it's pretty obvious what is going on there. So in these calculations, we have to put in the labor, materials, and equipment rentals. So all this is broken down in another sheet that gives a breakdown of this government form, and it shows that labor, which was all considered to be overtime, we considered that the 40 hours a week was what was required beforehand. to do, we basically dedicated 40 hours a week to the stuff that was normally under the contract, and then an additional 12 hours, or actually, to be more specific, an additional, 12 hours a week, 96 hours altogether of actual overtime that we were billing the government for. So the number of $7,200 is actually what was only paid in this portion of the calculation was $393.76, as shown from my first two paycheck stubs when I was paid overtime for working the hours over that Billy Tolson lied about in deposition, saying that he never saw a timesheet over 40 hours. In fact, in this time period, every single timesheet submitted shows I worked over 40 hours a week, which did not include travel time. The 6 trips to Florida where I spent about 96 hours just driving that I was never compensated for. So the breakdown of that is a little more important later on, and how it's abusive towards the employee, and I'll go into that a little bit deeper. Of course, the stuff that it would be normally taxed, had we had a contractor's tax exemption to use at places, then the material would get, taxed. However, I have all the receipts from everything, and we paid taxes directly at the point of sale. We didn't need to calculate taxes down here. However, I was told to put in the sales tax rate for the Nashville area. And that the rental equipment we had, which was a storage unit during this time, where the receipts are actually attached, was stuff paid directly without the taxes included. So as you can see, the taxes on materials, lines 6 and 7, the taxes are already paid. So this is 100% fraudulent $1,053.15. So this obviously goes to the breakdown, and I have another sheet where the real numbers of what should have been billed and what that comes to should have been. I produced this document on April 17th just to show this. I don't know why it says 2025. I might have done that on accident. However, I did this a few days ago, and the only line I changed, otherwise than the dollar values, was the revision to show the actual billable without defrauding the federal government. So this is what we should have charged in the request for equitable adjustment. And I'll break down those numbers verbally. That's backed up and verified by my timesheets, expense reports, and mileage reports. So what was legal to charge the government was $6,788.68 for this portion of the REA. What we actually charged the government was $24,274.99. So this is a cost breakdown for this RFP. As you can see, this was the information provided to me from the home office, where they say they spend $451.97 a day proportionally to this project as home office overhead. I believe this number is drastically inflated. This number, the one person's income does not match this, knowing that she made significantly less than this. So this is supervision, and this is overtime. It references the 96 hours that we billed for $75 an hour. Overtime, which came to a total of $7,200. What Acro Construction actually paid in overtime was $993.76. It was $991.88 from the first paycheck and $301.88 from the second paycheck. The only numbers that can be added to that, where we use correct overhead rate for insurance and taxes on labor, which is line 5, would be $90.56. So the total billing for labor was greatly inflated because of switching from hourly to salary. And I'm going to go deeper into that here in a little bit, but just wanted to make sure you guys are tracking well and on the same page. So these per diem expenses are also billed at a full government rate of $220 per day. All right, even though this says month, it was days, but I think we clarify it right here, 32 days at $220 a day. And this is based off the GSA rate that is the fair billing for meals and incidentals and lodging while traveling. And in fact, in this, I reference how that breaks down because this was from the time period of October, November, and December of 2016. The lodging per diem was $161 a day. The meals and incidentals were $59 a day, for a total of $220 a day. And I thought that was mentioned somewhere in here, but I can't find it right now. So this is going to be really easy for the judge to understand because it's the same, meals and incidentals and lodging rates. If a judge has to send his judicial assistant to another city to get training, this is what they'll be compensated for. So it's really real easy for the court to understand as well. So going back to the billing for this time period, and of course this is all backed up by my timesheets, mileage, and expense reports. The 32 days billed at 220 ended up being a total of $700 for meals and incidentals, because that would be broken down at $59 for 32 days. That $59 actually comes to $1,888 that we billed the government for. However, the records that I showed earlier only total up to $700 for meals and incidentals. And as far as the hotel and lodging rates are concerned, that $161 per day, part of that 32 days, would have come to $5,152 had they paid me like most contractors do. But the process was for me to hand in a receipt for the hotel, and I would get paid back for the hotel. Since I have all the receipts, I know that $5,152 billed for that portion of that line item, I was paid directly $2,765.31 for 32 nights in hotels. So we have an accurate record of what Acro Construction actually paid. And because this was no longer an estimate part of an RFP, because this was money already spent, and because it was money that we could only bill for, this shows the fraud where Acro Construction used comments from Adams and Reese, well, Trent Cotney then, Adams and Reese now, to defraud the federal government. And this is, a very common experience with Acro Construction. It happened, all the time. I would try to do stuff as legally as possible. However, it just didn't work that way. So here we have the travel to and from Florida. And this shows that 606 trips where there was 456 miles driven each way. So we billed the government rate for 5,472 miles that was actually driven, which came to $2,927.52. However, once again, the timesheets, mileage, and expense reports show the part of the travel that I was paid. Even though we billed the government $2,927.52, I received $842.56. So as you can see, that's another instance where we greatly overbilled the government. This is the only accurate number. This is shown by the receipts that I provide later in this, and this is the only accurate real number, because I know that the numbers that this Eichle formula was based off of was a fraudulent funding, just as this is right here. So, once again, this came up in the conference calls regarding the litigation. I brought it up because I wanted it to be accurate. It was deferred. Alan Cooper called me and said, hey, bill at $75 an hour for your overtime. Bill at $220 a day for lodging, meals, and incidentals. Bill at 53.5 cents per mile, even though we didn't pay that, because they said, let me give you the direction to put that number down, and that's an order. So this goes into some of the processes of how accurate construction defrauded the federal government. Not only do I have the receipts, I also know that Billy Tolson certified this under oath as accurate. So this was the meals and incidentals. Here is that Eichle formula showing that there is a total home office overhead annually of this amount for one employee. And here's my timesheets. So, to refresh your recollection, Billy Tolson testified in deposition he doesn't recall ever seeing a timesheet over 40 hours a week. Obviously, this is clearly a lie, just based on the defense discovery, because there's several references that show that that plaintiff's discovery even has references to Billy looking at timesheets on a weekly basis. So not only did he know, he willingly lied, knowing about that knowledge. He knows that Tamara and Alan are going to lie about the same fact matter. So that necessarily brings somebody who has knowledge of the situation and has the documented records of that as required, because attorneys have to keep the records, which I subpoenaed, which you guys are refusing to confer about, that shows that all 8 of these weeks in that time period I worked overtime every single day. So, not only was I very accurate with the government, I also noted whenever I worked less or more. So even though I worked a total of 43 and a half hours just this first week when this happened, all right, Monday was a travel day where I should have been able to put the 8 hours travel in there, but Saturday was probably a travel day as well, because I remember there was a lot of confusion around this. But these 43 and a half hours, because there was 5.5 hours dedicated to another project, and the rest of this time was dedicated to the Nashville project. At the bottom of every page, I actually put what we had invested in the Nashville project in my hours. I believe this is the only week where it was under 40, but the average altogether was 12 hours of overtime per week. And I go with the week ending days were always on Saturday. As you can see, there's 51 and a half hours, not including my travel time that week. And this was the last week I was paid on an hourly basis. So this was where, because the timesheets had to be printed and scanned, and I didn't have access to a printer at this time, I just emailed my hours and went from there. So there was a total of 45 and a half hours worked that week, but only 41 of them were dedicated to the Nashville project. And then we saw that there was a lot more engineering errors than originally anticipated, and I spent a lot of time weekly working on that. And with them not holding me back on overtime because I was now salary, they decided to abuse that process. So even though this shows 67 and a half hours of working, there's also, 96 hours of travel time that was never, accounted for. This is every week, 57 and a half. 61 and a half, 53, 57. So I have an accurate timeline of everything we submitted to the government. Every week showed that I worked more than 40 hours a week, which is lied about in the deposition of Billy Tolson. So let's go a little bit further into this and how those numbers break down that I gave you to show you where Acro Construction is defrauding the federal government. So if you go back and look at the timesheets and mileage and expense reports, you'll notice that I was paid dramatically less than $75 an hour. I was paid, I believe it was less than. So I was paid $17.50 an hour. On the overtime, I was paid $26.25, where the what Acro billed the government was $75 an hour for the $26.25 they actually paid, as shown by this breakdown. So this is relevant. This was created back on April 17th, and what was actually billable as overtime is this $393.76. This is before the overhead on labor, which is called insurance and taxes on the government's form, and should have been billed at 23%. This was one of those numbers that was also discussed with Adams and Reese, is what the actual overhead is, because at times they would have me put 20% in, at other times it was 25%, and at other times it was 30%. This 23% overhead was what we finally determined as the value. So it's an accurate representation. So altogether, the billable allotment for the insurance and taxes is broken down right there. And once again, I took out the state sales tax off of lines 6 and 7, which was the rental and my travel expenses, because it was already paid for directly. So the billing to the government being over $24,000 for this section of the work, which is best represented by this, because the home office overhead we couldn't put into this calculation because you can't get overhead and profit off of the home office overhead as it's used in the Eichle formula. So knowing that that was also fabricated, as there was only one person working at the office and there was no the person, at most the home office overhead was $100,000 altogether. The building was owned, they pay taxes on it, so you've got the factor there. They leased out the outbuilding to Billy's son, Stephen Tolson. Of course, he might have been paid for helping with the litigation back then, as you know, for a free place to stay. And Billy Tolson owns his house right now. So when Billy Tolson lied to the process server, that also becomes relevant. However, I'm trying to stay focused on the fraud against the federal government and how Adams and Reese has knowledge of that based on the conversations, some of which I have recorded, all of which Alan Cooper says was directed by Adams and Reese. So, and that we know Billy Tolson lied during the deposition. So to break down what happened on the labor side of things while this happened, obviously the 393.76 doesn't add up to the 7,200 in the other area. And I thought I'd go through and explain what happened with the labor rates and agreements. So at the beginning of this, I was paid for my mileage per the government standard rate at that time, the IRS rate for mileage, and I was not paid for my travel time. So this was during the first week, and then it became a negotiation because they didn't want to pay the mileage. They then went to paying me a flat $50 a week for all travel related expenses. So in addition to changing from hourly, the whole scheme was changed. So I was given a flat $100 a week anytime I worked even a day out of town, which does not add up to the $59 a day GSA rate, which is considered a fair rate. So, on addition to that, we have they gave me they at the beginning of this they were paying me 56 cents a mile, which was the rate from 2016 before the IRS rate was adjusted downward to the current rate when we did these REAs. And they stopped paying me mileage altogether and gave me a flat $50 a week. So it became abusive from Acro Construction when they said, well, you need to be in Nashville and we're going to pay for it was 56 total days that was, in between those 8 weeks. And 32 of those days were spent at a hotel in Nashville with 6 trips. So I was paid for total travel $842.56. So this evolving standard became paying me for mileage and hourly for my work to salary, where I was forced to work more overtime because they didn't want to pay the overtime, but what was needed to get the job focused required more overtime, so that was part of the scam. And then the because the $50 a week got abusive, they wanted me to spend $200 on gas to travel back in Florida 6 times during this 8-week period and only pay me $50 a week. So towards the end of this, it changed to where I got $50 a week plus my gas receipts. But that was only paid one time. So out of the 6 trips back and forth to Nashville, I was only paid for one trip getting the $50 a week plus gas receipts. So it changed in that factor pretty significantly. I always turned over directly the hotel receipts, but the actual overtime that the government was billed was should have been $393.76 because there was no overtime on the salaried wages, the exempt wages, I should say. So this is just one method that Acro Construction uses to defraud the federal government through its labor kickback scheme by billing the full rate that the government could pay. And the subject matter that I brought up was that this is no longer a proposal or an estimate. These are known actual numbers where I was paid less. Can we still bill the government like this? And the answer was directed for me to put the numbers in there as it was directed by my employer, and that the council knew of this fraud that was going on because I explained it, and they agreed that we couldn't bill, but they could direct me to place those numbers in there, which essentially was a condition of employment. So this shows directly how this labor kickback scheme was operated at that time, and the fact that Billy Tolson lied under oath in his deposition. Now, when it comes to Billy Tolson's deposition, obviously, I have recently recovered, I believe the date was on March 20th, so a month ago, I recovered a hard drive from my computer where these phone conversations were downloaded. Now, it downloaded all the conversations from my phone, so I have not started reviewing them yet. I am backing up that hard drive to Dropbox. I went to start that, and it said it would take over 4 or 5 days for it to upload. So I stopped the upload, and that way I can have everything documented by the date that the documents actually were saved to the computer. That way you have all the metadata available. But this is before I can go through and separate all my personal phone calls, because I was not provided a company phone. In fact, I paid for all of my phone service. I paid for all of my computers. I was originally paying for the service on the computers like Microsoft 365 and Adobe and stuff like that. So I initially paid for those, but that's not in the time frame of the complaint. So even though it was in the original complaint, it was removed by document 96 because it's not in the time frame. But that was a condition that happened early in my employment. And the essence of this goes to records maintained by Adams and Reese. So this was from an email sent to everybody when they instituted the lawsuit against the Department of Veteran Affairs. Of significant focus on that is that all these REAs were submitted in January of 2018. So I've given you just one of the numerous REAs where I'm showing labor kickback scheme evolved and the government was fraudulently overcharged because it was no longer an RFP, it was an REA. So they had me use the numbers knowing that they had overinflated those numbers and go from there. So a significant portion of this is I don't have the actual document that is signed under oath. As you can see, this is regarding the oath sections under the Federal Acquisition Regulations. I don't have the actual document. That is maintained by Adams and Reese, which was merged with Cottony Construction Law back in 2022. So even though these records are from 2018, it proves Billy Tolson knowingly and willingly lied during deposition, and that counsel knows that Billy Tolson willfully and knowingly lied during deposition because he submitted a claim for over $100,000 for work performed prior to the termination date for costs incurred with the project in the REAs. And he knows that he was central to the fraudulent records being produced, as there's many recorded conversations regarding all of this, and that is part of the reason why I'm doing the YouTube video, is so you know that if Adams and Reese continues to do this, then these records that I was required to record as a condition of my employment back then, that I'm going to make them public. I'm going to show more and more how this fraud occurred and how it affected not just me, but numerous other employees. Unfortunately, the Zafarov versus Florida Medical Associates case that is now in the 11th Circuit kind of prevented me from having counsel, and I wasn't really understanding of the tolling of the statute of limitations that applied when I filed a Department of Labor complaint. So that is part of the reason why we're going through this now. And just for reference, when you add up the number of hours I worked after I became salary per hour, it was less than I was making as an hourly employee on overtime. So it was a pure scam by Acro Construction. And like I said, only that 1 week, one time going back and forth from Florida. So the one travel was just to Florida where I was paid by mileage. So that was a one-directional travel. The other time it was both directions, include the $50 a week and nearly $200, which is shown by the timesheets, mileage, and expense report. The other 9 trips, one direction, 4.5, going back and forth to Florida to Nashville. Of course, it did not include the 96 hours of driving time, which is 96 hours driving through Atlanta, which if you happen to do it during rush hour in Atlanta, that 8-hour drive becomes a 10-hour drive, or if you try to do it in the middle of the night, is actually probably a 7.5-hour drive. 8 hours would be an average. Some of this stuff needs explaining because no matter how much I try to explain and talk to Mr. Briggs, he decides to say, hey, well, I only have 15 minutes to talk. That's all you're going to get in this conferral. As you can see, as long as this video is, and having to explain it more in depth and showing how Adams and Reese continued representation shows their willingness to participate in the fraud against the federal government, I am hoping that the conflict becomes prevalent, because Mr. Briggs knows there's direct adversity, and we are going to move forward with this and go on to bigger and better things. And hopefully, with counsel being removed from this case, I won't have to file additional paperwork for years to come. Hopefully we can get counsel representing each defendant, knowing there's no direct adversity when people have individual counsel, and go from there. Please feel free to give me a call regarding this stuff. I have been open to conferring throughout, and I look forward to the completion of this video here in a few minutes. I also addressed deposition testimony of Mr. Billy Tolson that I believe shows direct adversity among represented parties as part of this conferral. In short, there is no unified defense when discovery has clearly shown that one defendant must either perjure themselves to lie with a co-defendant or testify against them. I don't like to divulge impeachment evidence, so I'm not going to. It is counsel's responsibility to confer with each client to ensure that there is a unified defense. He cannot simply exacerbate the lie of Alan Cooper, Tamara, or Billy, anyone else, and not ask each client for information on the truth regarding their knowledge. As the case has progressed, I have been fully honest with discovery, even sending Mr. Briggs live documents to ensure the calculations of damages are accurate, with Mr. Briggs not participating. The process of discovery is to bring honesty to the entire litigation, to which Mr. Briggs has simply not participated. Mr. Briggs has not engaged in meaningful conferral on several key issues, especially where I asked direct questions about conflicts, falsified evidence, proper parties, subpoenas, and contradictory or self-serving discovery from the defense. The discovery record in this case shows I am more than merely attempted good faith conferral. I went far beyond what was required, and the time I invested in attempting to work in good faith is good cause, not just for removal of counsel, but for newly discovered or freshly recovered evidence to be part and parcel to the record. I also understand that counsel asked about my reference to a YouTube channel. I changed the name of my YouTube channel to Whistleblower Chris in July 2025 because I intend to discuss federal contractor fraud, payroll practices, labor kickback schemes, IRS fraud, and litigation records from my first-hand documentation while working with ACRO. I'm not using this video to infer fault of any counsel, but when I start reviewing the recorded calls of Adams and Reese as counsel or any party conversation that exposes the schemes, I will certainly publicly release the recorded evidence which shows the knowing conflicts of interest, as counsel has refused to confer. I am documenting why I believe the conflict issue, the prior litigation records, and the alleged inconsistencies in testimony require court attention. Any public commentary I release will be the result of failing to meaningfully confer now, and contend I will make, and the content I make will be based on records, exhibits, deposition testimony, and my own first-hand document-based recollection. I continue to ask counsel to meaningfully confer, correct any material inaccurate statements to the court, address the conflict issue, and preserve the records necessary to resolve these matters fairly. I also request Mr. Batcher, Mr. Cotney, and Mr. Green call me to discuss the relevant testimony, as the court orders require open communication with prospective witnesses, not gatekeeping by Mr. Briggs. So, I close out this conferral with an evidence-based discussion. Mr. Briggs knows I have been completely honest and transparent. There is no fact he can logically dispute in the complaint where I have not addressed any error and tried to confer on the matter. A prime example is where I discovered when Acro Construction refused to fund an expense report. Their lies made a confusion on the allocation of monies, where I was in fact paid for materials, but then they refused to pay when I had to pay a subcontractor in cash more than $1,000. and the confusion was caused by their own failure to maintain accurate records and the miscommunications in those inaccurate records. So when I received my bank statements, I tried to confer on the matter with no substantive response from Mr. Briggs. Another instance is when I used an AI program and found out that on both the Maine and Booker T. Washington projects, I mentioned there was no metadata at first. The AI program that there was some hidden metadata in the redaction process, where those two projects shows Alan Cooper as a project manager, which since Alan was paid by profit share only, was proof of actual falsified certified payrolls. This is also confirmed by the cost data sheets for those projects that show Alan was not paid on a weekly basis. Hence, the reason why Mr. Briggs knowingly and actively prevented disclosure of cost data sheets when he directed Billy Tolson not to bring them to the deposition as requested by the subpoena decus tecum for deposition. Mr. Briggs' deliberate gatekeeping of relevant and admissible records show he is deliberately manipulating the court. I took longer than anticipated creating this conferral record, as the court inferred a lot in the R&R, which is based on the responsibility of candor by an attorney, as an attorney must provide to the court. So, my comment on the court advocating defense is likely more due to the lack of candor by Mr. Briggs. When an attorney insistently says there is nothing to see here because he is the one ultimately responsible in hiding the truth, then the court makes inferences on review without knowing that dishonesty of Mr. Briggs is what is causing the false inferences. So it is now the responsibility of Mr. Briggs to act with candor and correct the record. Notwithstanding the overwhelming evidence there is a conflict of interest, I imagine the court is going to want to have answers. I know that the deliberate gatekeeping by Mr. Briggs, while knowingly representing conflicting interest, is going to have him falsify information to the court and fail to correct the record once again. So the court's direction for not allowing leave is dismaying, but I am ready with the truth, ready to confer, and look forward to addressing other newly discovered and recovered evidence, and look forward to the conversation and conferral. My phone is always on. Quickly, regarding newly discovered evidence. Mr. Alan Cooper and Billy Tolson had both previously been in conferrals with the Department of Labor, to which Billy Tolson lied during deposition. Both Acro Construction and Alan Cooper have resisted Department of Labor investigations, and the outstanding records from Department of Labor should be available in the next 60 days-ish. This directly goes to knowledge in the complaint investigated by the Department of Labor in 2024 and 2025 and shows the deliberate manipulation of information of the Department of Labor, which I believe should show that Cooper Mechanical and Acro Construction have been previously counseled prior to issues they denied knowledge of during that investigation. Because the information is partially redacted, the investigation process was obscured through false assertions, I invite you to authorize the release of all records from all defendants and request the information directly through FOIA request as well. I also think conferral on these matters will prevent numerous subpoenas to the court. Other newly discovered evidence includes what I misclassified as an hourly, when I was misclassified as an hourly laborer on the Gainesville project. When email records show on the project that I was supposed to be paid the prevailing hourly wage on the project, this shows the manipulation and falsification of certified payrolls to the federal government is inextricably intertwined with the unpaid wage labor practices of Acro Construction, Alvarez Inc., and Cooper Mechanical. Unknown to me until I received a defense discovery and then confirmed in review of my own bank records when I received them, is the actual theft of hours from my own overtime and handwriting appearing to belong to Alan Cooper. Even though I had proof of removing hours off of the properly timesheets of others, I now know that involves me as well, in the sum of multiple thousands of dollars, which was knowingly taken off of my paychecks, regardless of the changing conditions of the terms of employment, and shows willingness to defraud employees beyond their labor kickback scheme. I look forward to discussing these matters prior to the submission of any response to the report and recommendation, and look forward to Mr. Briggs acting with candor for the first time in this case. This is more than cause to amend the complaint anew and request conferral on the matters immediately. If Adams and Reese does not withdraw as counsel because with the continued falsification of evidence and self-serving declarations of the defendants to hide the contradictions to unified defense theory, Adams and Reese is just as liable to defrauding the federal government as Acro, Cooper, and Alvarez, where I have no problem announcing culpable parties who continue to hide the truth, and I will do so very publicly.